Hello, and thank you for joining us for this Lawyers for Learners webinar, welcoming asylum seekers. My name is Katie Chu, and I am a project specialist with Lawyers for Learners, and I am so grateful to be here today. And speaking of gratitude, we are honored to have Aissa Olivarez, a managing attorney for the Community Immigration Law Center, here with us. Thank you, Aissa, for joining us today and sharing your expertise on the topic of asylum. And with that, I'll turn it over to you.
Thank you so much, Katie. Welcome, everybody. Thank you so much for having me here. I'm excited to talk about this work, although it is heartbreaking being able to share the information that empowers asylum seekers and also the community to welcome them with dignity is so important to me and the Community Immigration Law Center, our organization. Next slide, please. Just a quick disclaimer that the slides are not intended to give any kind of legal advice. And so while I will be giving and talking about legal standards, this does not constitute legal advice. And if there are questions that are legal in nature about an individual that you might be serving, please seek out the advice of an attorney for that particular case. So today we're going to talk about what asylum is and who is here in the United States seeking asylum right now, what eligibility requirements might look like, what protections are involved for people who are seeking asylum, how to apply for asylum, and also how people who are non-legal service providers can assist asylum seekers. There are so many ways to be able to do that. And so we'll be going through this today. This is going to be a quick presentation. I have an hour, so I'll be sort of flying through the content. I will have time for questions at the end. One thing I do want to note is that I could do an entire semester course on asylum. And so getting it in 1 hour is going to be quick. It's just very high level, and want to be able to note that to you all as I work through these slides. And before that, want to be able to share with you the experience of our legal intern this summer, Karen Perez-Wilson. She was here as a part of Lawyers for Learners. Very grateful for her help this summer and want to be able to give you a chance to hear from her directly on her experience.
My name is Karen Perez-Wilson. I am a third-year law student at UW Law. I had the great privilege of being the legal intern at the Community Immigration Law Center. I first learned about CILC in 2018 when I volunteered as an undergraduate student. I was thrilled to learn about their job opportunity and decided to apply. I was so grateful to have had the opportunity to work at CILC alongside incredible attorneys and paralegal. This summer, I assisted with filing over 20 asylum applications, completed client intakes, renewed work permits, and won an asylum case. I am thankful for Lawyers for Learners and CILC for entrusting me in this role. I look forward to taking what I've learned to be a greater advocate for immigrant rights, especially within our community. Thank you so much.
A little bit about the Community Immigration Law Center. We were started in 2009, and we are housed inside of Christ Presbyterian Church here in Madison. Very grateful to them for all of the support that they've been giving us as we launch this work to be able to serve our community in the way that they need. We have a biweekly legal clinic that we are able to serve people through. We've served over 4,500 people from over 160 different countries. We also provide direct legal representation to individuals who are at risk of deportation or who are Afghan refugees here in Wisconsin. And we also help people fill out their asylum applications, and you'll learn quickly here how difficult the process might be. We developed this pro se program to be able to help people through it and understand what their rights are and what the process looks like as they navigate trying to find protection here in the United States. So as you're waking up this morning, as you're sipping your coffee and listening in, I want you to share in the chat, what does the word asylum mean to you? A lot of us have heard about it in the news. Maybe some of us know an asylum seeker, or maybe some of us have even sought asylum and live here in the country as asylees. And so share in the chat. Want to hear from you. What does the word asylum mean to you? As you get that into the chat, I'm going to talk a little bit about the asylum seekers that we are seeing here in the United States currently. We know that there's many individuals here who are seeking asylum. More than ever, currently people are displaced worldwide as a result of persecution, violence, and human rights violations. So more than 8 million people have been displaced, 8 million more people than the year before. So 108.4 million that are currently displaced. And you can see the numbers broken down at the bottom. 5.4 million of those individuals are asylum seekers. And asylum seekers arrived to the United States in many different ways. Over a decade ago, there was people from Central America paying thousands of dollars to be able to arrive here at our most southern border. On the bottom graphic, you can see the different routes that individuals take to be able to come to the United States. The furthest route being to Arizona, Nogales, which is the most dangerous route, as well as you have to travel through the desert to be able to arrive safely at the US border. Right now, there is a current policy by the Biden administration that's made it even more difficult for individuals to seek asylum. It's called the circumvention of lawful pathways. Unfortunately, many people are being subject to a heightened standard to be able to seek asylum here in the United States and reunify with their families. And we've seen many people being returned to Mexico or to their home country upon entry to the United States if they haven't presented themselves lawfully at the border. One thing I wanted to share with you all, just a quick quote. This is a picture taken from the border, directly seeing, women and families cross into the United States. And so the quote on the next slide is, "No one puts their children in a boat unless the water is safer than the land." And so US law enshrines the protection of the International Refugee Convention. And the law provides that any person physically present in the United States or who arrives in the United States, irrespective of such person's status, may apply for asylum. And so people who seek asylum in the United States come in search of safety from persecution, torture, and often death. But upon their arrival, they face a new odyssey of navigating this complex US immigration law and an increasingly restrictive environment that bars asylum seekers from being able to seek this protection here in the United States. Hence the program that we launched here at the Community Immigration Law Center, when we saw so many of our community members unable to navigate this difficult area of law. And so with that, I'll talk a little bit about, what does this look like? What are the requirements to qualify for asylum in the United States? Want to talk about first what the benefits are. When people are able to seek asylum, they are able to obtain a protection from deportation. And so on the next slide, you'll see a short list of what those benefits of asylum are. Again, protection from deportation to their country of origin, work authorization, although they do have to wait until they apply for asylum to get that work authorization. But once they're given asylee status, that work authorization is granted immediately. They're also eligible for Social Security numbers and driver's license. Important to know that asylum status does not expire. People remain asylees even if they don't ever apply for their green card. So people will always have that protection as an asylee if they're granted asylum here in the United States. Now, as lawyers, there are eligibility requirements under the law that people have to show in order to be eligible for asylum. And so they have to show a fear of persecution. And I can teach a whole class on just what persecution is under the law. And so again, this is a large overview, a very overhead overview of what is asylum. So fear of persecution of the government, of your country, or somebody the government doesn't want or cannot control. And all of this has to be on account of your nationality, race, religion, political opinion, or being a member of a particular social group. So we have to show a nexus here for that fear of persecution. It has to be on account of one of those 5 things or a mix of those 5 elements there. Again, I can teach an entire class on what particular social group means and how it's defined under the law, because case law is constantly developing around that. But these are the requirements that you have to show in order to be granted asylum. There are also future persecution claims that people can launch through that form I-589 that they file for asylum. So even if you have not suffered persecution in the past, you might still be eligible, and if you can prove that you have a well-founded fear of persecution in the future, right? That maybe nothing happened to me in the past, but because of something I participated in, for example, an anti-government protest, or because of my political opinion or a way that I'm affiliated, or because of a certain identity that I hold that I cannot, right, erase, that's ingrained and is a part of me, then if you're able to show that well-founded fear of persecution, you can proceed with an asylum claim, and you can win asylum based on that future persecution claim. Now, there are people who might not be able to move forward with an asylum application, or who might be denied asylum if one of these things happened. There is a 1-year filing deadline with some limited exceptions. So people must file within 1 year of arrival to the United States. Again, we were finding that many of our community members were missing this 1-year deadline because when you arrive to the United States, many times, you're trying to get settled. You're trying to get settled in the community, find out where to live, get kids enrolled in school. It can be really hard to try and meet that 1-year deadline when you're in a brand new place and you've left everything behind in home country. And so we stepped in to try and help people meet that 1-year filing deadline. So again, there are types of protection that people can be eligible for past that 1-year filing deadline, but that 1-year filing deadline, very important to be able to preserve eligibility for full asylum protection. People who have committed particularly serious crimes here in the United States are also can be found ineligible for asylum if the country conditions in their home country have changed in a material way, or if they have lived in a different place safely before coming to seek asylum. They might not be eligible or found eligible to win asylum. Also, individuals who have participated in hurting others based on their race, religion, nationality, or being a member of a particular social group are ineligible for asylum. There is a lot of discretion, as it says at the bottom, for people to decide also in this case. And so judges can find that you've met all of the requirements, but that you don't deserve asylum as a matter of discretion. So immigration judges can deny asylum just as a matter of discretion. There are so many other factors that might impact an asylum case. In this case, when I talk about an immigration judge, it's people who are seeking asylum as a defense to their deportation because they are in removal proceedings. And so different immigration judges might rule in different ways. Different courts might rule in different ways for asylum seekers. Also, certain countries that people come from have more, the judge might have more information. And so we see people from certain countries of origin also win asylum more frequently, depending on where they're from. Also, what the current conditions are. Conditions in countries, although they cannot change overnight, are often shifting. And so when it comes time to adjudicate your claim, what is happening on the ground in your home country currently? It's something that you have to be able to show and prove. And having an attorney representing you, people are 10 times more likely to win their case before an immigration judge when they have legal representation. Unfortunately, there's not enough legal representatives with the number of asylum seekers here in the United States right now to be able to serve people on a low bono and pro bono basis. Even private attorneys have a hard time meeting this capacity because of the numbers that exist. On the next slide, I'm able to show you some of that data from the Immigration Project at Syracuse University. And so this was obtained through Freedom of Information Act. I know that it's really small, but you can see just within our Chicago Immigration Court, and some of these judges are still there and some are no longer there, but you can see just how even by immigration judge, different ways that people might rule on asylum, right? You see somebody with a 9% grant rate in the same court as somebody with, right, an 82% grant rate. So the judge that you have can make a big difference in a defensive asylum case. On the next slide, you'll see by immigration court. You can see the Georgia Immigration Court is granting 9% of cases. The Hawaii court is presenting, is approving 56% of them. And so, 66% of them. And so, the place that you have to be in immigration court, depending on where you're living, also makes a big difference. And finally, as I mentioned earlier, the country of origin of the asylum seeker. So you can see that people from Mexico only have 12% of their cases granted, whereas anybody who might be seeking asylum from Syria has the highest grant rate from when this data was taken. So just want you to see all the different variables that exist, even while people are trying to share with an immigration judge all of the trauma and crazy, scary things that they went through. And so even with having to do that difficult sharing of their narrative, they face all of these different variables. And again, attorney representation, as you can see on the next slide, up to 10 times more likely to establish a right to remain in the United States. And so very important to have an attorney, although there's just not enough of us doing this work right now. And so if I have any attorneys on here, I'll share my information at the end who are interested in taking asylum cases. Please feel free to reach out. It is a difficult area of the law, but one that CILC helps to support attorneys who are willing to navigate that with us. I mentioned earlier that people who might not be eligible for asylum are still eligible for other types of protection. And so even if they don't meet that criteria for asylum, that I-589 asylum application actually gives you the chance to apply for withholding removal and protection under the Convention Against Torture as well. And so if you do not meet the eligibility requirements for asylum, you might meet them for withholding of removal, although there are higher standards for withholding of removal and for protection under the Convention Against Torture. There's just a different analysis that's done there and different standards that apply, higher standards that apply. But it is something that the judge considers if you are ineligible for asylum for any of the reasons that I read earlier. Now, when I talk about asylum, it's important to know that there are affirmative proceedings. And so you might have heard of people who come to the United States lawfully, they have a visa with them, and then they apply for asylum before the asylum office. In our case, the Chicago Asylum Office, because of where we are in the region. Nice thing about affirmative proceedings when people enter lawfully and apply for asylum affirmatively is they get two bites at the apple. They get to see if USCIS and the Chicago Asylum Office is going to grant them asylum. And then if that is referred, it might be referred to an immigration judge, but they have two different entities that listen to their claim before they get that a decision. Whereas when you're applying for it as a defense to your deportation, which is what we're seeing a lot of individuals here in our community apply for defensively, they get one bite at the apple. Technically, if they appeal, there's two bites, but there's not necessarily a de novo review of some of those elements. And so it just depends whether they decide to appeal or not. But with the immigration judge, it's basically, that's the one person who gets to review it and gets to decide. In the affirmative proceedings, they're non-adversarial. You're sitting across from an asylum officer. They're asking you questions about your claim. You have an interpreter with you, maybe sometimes an attorney with you, but there's not an adversarial setting. You don't have somebody there who is fighting for your deportation as a government attorney. There's somebody there who works for the government who's asking you more about your fear. But in the defensive proceedings, it is adversarial. The Department of Homeland Security is represented by an attorney. They are sitting at counsel table, and they are there to cross-examine you, and they have questions in the courtroom for you. This is a trial where there is evidence and testimony presented, and so there is a more adversarial setting in the defensive proceedings. And this process can take a long time in both places, sometimes longer in the affirmative piece. But if people are applying for asylum as a defense to their deportation and they're detained, things do move rather quickly because of them being detained. But we know that people are waiting months and years to hear more about their asylum claim after they apply. Again, how do we apply for asylum? There's an affirmative way to do it, or there's a defensive way if you are in removal proceedings. The form I-589 is the form that needs to be submitted according to which type of asylum you are applying for. If you're applying before our local asylum office in Chicago, or if you're applying as a defense to your removal before the Chicago Immigration Court in our region. And so if you are applying defensively, again, you need to provide address updates to the court, often filing a change of venue if you've moved to a different jurisdiction and out of the jurisdiction of your local court, filing the form I-589. It is available at uscis.gov. Going to a biometrics appointments here, they could be in Milwaukee or Waukegan. Also, when you apply defensively, it's sort of like a trial. You have to prepare evidence, you have to prepare witnesses, experts, testimony, and a legal brief. The rules of evidence don't apply in immigration court, but we push hard as defense attorneys to make them or have them apply as much as possible to both counsel and the counsel for the Department of Homeland Security. One thing that people can and have eligibility for once they apply for asylum is a work authorization. Unfortunately, they have to file the I-589 application first, and so they're not eligible for work authorization upon arrival to the United States. They have to file an I-589 application. That starts what's called an asylum clock, and they can apply for it once 150 days have lapsed on that clock. There are exceptions to this. If there's any applicant-caused delays, that clock will stop. The example here is change of venue. Change of venue actually no longer stops the asylum clock. That's how quickly things change in immigration law, is that I didn't even get to update my slides. So change of venue no longer stops the asylum clock. But things like asking for a continuance or more time to find an attorney after you've already filed your asylum application, those things can stop the clock. And those applicant-caused delays then mean that people have to wait to see a judge again before their clock starts, and it can be really disruptive to whether they're eligible for work authorization. Once their case ends, if they're granted, they're given asylee status. If they're denied, they'll lose their work authorization once this case concludes and their EID expires. We do know that they are being given work authorization currently for 2 years when they apply based on having a pending asylum application. And there are some automatic extensions due to delays by USCIS currently. And so important to note that if people present an expired EAD to employers, it could be that an automatic extension applies. Asylum seekers here in the United States, and particularly in Wisconsin, because of the just the lack of resources and capacity in the state, there's many challenges that people face when they come here and to seek asylum and start to navigate our community. And that's why we call this welcoming asylum seekers. People face really harsh conditions at the border. Currently representing a young woman who is in the Laredo facility and has been there for almost 2 weeks, a young girl who is, really struggling with the conditions that are within the facility, only able to shower every 72 hours, being given frozen food to eat. And so really important to know that when we create this program and when we do the work with asylum seekers, that we approach them in a way where we meet them with dignity, because unfortunately at the border they're not being met with dignity or treated with dignity, and it is a right to seek asylum here in the United States. And so I share this information so that we can welcome people to Wisconsin with dignity, with hope, and with love, because what they're facing again on the border and what they've faced in their home country is incredibly difficult, and we want to be a change to what they see, a welcoming face here in the United States. So the process for asylum can look many different ways. It's changed during administrations. Title 42 was in place for some time. People were not allowed to seek asylum. Now we have the circumvention of lawful pathways. And so this process looks different right now than it did last year, and even than it looked the year before and pre-COVID. Pre-COVID, people were taken into facilities and given credible fear interviews, and then they were released if they were found to be credible in their interview, or if they were not, they were deported. Right now, we're seeing them be held to higher standards due to a new Biden administration policy, that if they did not enter either through the CBP-1 app or presented themselves at the border, if they're found in between, after crossing into the United States, they're held to a higher standard, and they're being held in these really difficult facilities along the border while they're waiting for the adjudication of whether or not they can proceed with asylum. There's also very high costs and lack of capacity in here locally. While applying for asylum is free, right? There's no filing fee for the I-589 application. Attorneys can be expensive because so much has to go into these cases. Attorneys need to spend a lot of time being able to prep their legal briefs, their testimony. If there's an expert witness, paying for experts. It's always really helpful to have country condition experts and psychologists weigh in for immigration judges when they're trying to decide whether or not people meet the elements for asylum. Also, if they came with their families, there's additional costs there for those family members to be represented. And so, it can be very costly to try and seek asylum when you apply through an attorney because of all of the time that has to go into this. Work authorization, the first work permit is free, but after that, every 2 years, it is a $410 fee. And many times, once people get settled here in the United States and they have a case, they start to pay to bring family members from abroad to reunify with them so that they're not separated from their family. And that can be very costly as well. Additionally, there's often a lack of stability and lack of access to the legal system that they have to navigate to be able to gain asylum here in the United States. We know we have a housing crisis nationally, and we see many people who have had a hard time being able to find housing here in the United States. Sometimes people have families and they're able to stay with that family for some time, and then maybe a landlord finds out there's too many people, or they didn't have family here. It can be incredibly difficult to try and navigate that piece. Food insecurity is also something that we see people struggling with, and workplace violations, especially before they have that work authorization. People have to work. People have to be able to support their families and pay for housing. And often we see people who are subjected to workplace violations because they might be working without authorization, or because of their lack of fluency in English, or they're just seen as a vulnerable population. And so these are often issues that we see arise with the people that. When I talk about a lack of system accessibility, I'm talking about being unable to navigate the system on a pro se basis. It's very difficult to be able to do this on your own. hence the program that we created here at the Community Immigration Law Center. The forms that you submit to the government, whether affirmatively or defensively, must be completed and filed in English. Many people who come here seeking asylum are not coming from a country where, you know, English is the native language. And so helping people to translate that information into English so that they can submit their applications and they will be accepted by the government. All evidence that's submitted also has to be in English. And so if they have testimony or letters from people in home country, having to translate those so that they can be submitted as evidence as well. It is really hard, again, here to navigate this on your own as a pro se litigant. You know, EOIR and ICE are not necessarily responsive to the needs of people unless there's an attorney sort of on them, behind them, bothering them about what needs to happen and making sure that their rights are preserved. And so really difficult to navigate this on your own, although our program tries to prepare people as much as possible to be able to do this. And again, sometimes people lose their correspondence. I talked about this housing crisis, housing instability. People often, you know, have to move suddenly or getting evicted, and they might leave, you know, important paperwork related to their case behind, and that gets thrown out. And so very important, that paperwork helps us to know as lawyers what's happening in their case. And it's really helpful to them as they start to navigate the system as well. So if you're helping anybody who might be going through the process, you know, just helping them be able to scan their documents and keep them in a safe place is really important. And so with that advice, what can you do, right? How can you assist asylum seekers to be able to navigate this process? There are a lot of things that people can do even before the asylum case is concluded, and even after the asylum case is concluded, as people who are non-legal service providers. And so we know that people often who are seeking asylum as a matter of a defense to their deportation have to check in with ICE, sometimes every few months, sometimes annually. It's important if you speak to someone that you know is in removal proceedings or that you know wants to seek asylum affirmatively. When did they enter the United States, or when did they lose status? The status that they entered with. They're going to need to apply for asylum ahead of the 1 year of either of those things happening. It's also important to connect people that you might know with counseling or therapy. People have been through a lot. Just talking about earlier, the person that I'm serving who's on the border currently, you know, there's trauma even just arriving at the United States, and the lack of dignity and the lack of due process, lack of rights that they have when they come to the United States, that on top of what they've already suffered for their reason for coming to the US. And so getting counseling and therapy right away can be really important to their well-being here in the United States. Again, I know mental health services, helping people with changes of address, which can often be done online, helping them get to biometrics appointments. We're really lucky here in the Madison area through the Dane Sanctuary Coalition to have a group of volunteer drivers who take people to Milwaukee or to Waukegan or even to their court hearings in Chicago. When you don't have a right to a driver's license, as people who are undocumented here in Wisconsin, they do not have a right to a driver's license. It can be really difficult to travel. And it's a risk to travel even. And so being able to provide that volunteer support, very, very important. Again, I mentioned earlier, scanning and taking pictures of paperwork in case any of that paperwork gets lost while they're navigating and trying to get settled here in the United States. One thing that the government launched during COVID is WebEx. And so people are able to go to court via WebEx in some jurisdictions and only for some judges. It's important to know that this is not a default to access court via WebEx. Often you have to ask to be able to appear via WebEx, especially as a pro se litigant, but it is something that is available in some courts in some areas, and I'll show you soon how to access that. Also, some people might be eligible for a driver's license if they can show certain documentation that they are in removal proceedings, and so a notice to appear, with proof of address and a photo ID, they might have access to at least a Wisconsin identification and eventually a driver's license if they're able to pass the exam. The exam is given in Spanish at the DMV as well. I'm not sure about other languages, but I can confirm that it is given in Spanish. And so there could be that there is the chance to apply for a driver's license with certain documents that the government gives you when you enter at the border. After the conclusion of an asylum case, people become eligible immediately for benefits. There's things that they have to register for. If you can refer them to a resettlement agency that has lots of experience with this, that's wonderful. But just knowing that they might immediately be eligible for benefits, that they need to move on within 30 days, getting them access to people who know how to navigate those resources, getting them a Social Security card that's unrestricted, ongoing therapy, because again, this is something, the trauma that they've suffered back in home country is something ongoing. And they might have suffered also from family separation for quite some time, which can be incredibly difficult. And so ongoing mental health assistance, housing, and also, getting an unrestricted driver's license. If asylum is denied, that person can appeal within 30 days if that's something that they are interested in, but you can also help the family with deportation planning if they decide not to appeal. What are conditions like back in home country? What is the plan for returning there? Can you help them navigate all of those pieces before they are deported? You can also assist people with trying to figure out where do I need to be and when. When people have their paperwork, you're going to see different dates and times. Often they have to be at ICE check-ins in Milwaukee. Important to note, ICE in Milwaukee does not decide on your asylum case. ICE in Milwaukee is there to monitor that you continue to be in the United States so that you're abiding by the rules of release when you are released at the border. They're not there to decide whether or not you win asylum. The immigration court, when you are applying defensively, and the immigration judge are the individuals who decide on whether or not you are granted asylum at a hearing that you have in the Chicago Immigration Court. And so those things that happen in Milwaukee are just check-ins to monitor that you continue to be in the United States and that you're abiding by the conditions of your release. The immigration court is where the actual decision will be made. ICE check-ins in Milwaukee are incredibly important. It can be that people, there is some delays in their case if they are unable to check in. And so very important if you're able to help people be able to get to Milwaukee on those dates that they have a check-in, or change the date for a day that they can attend those check-ins in Milwaukee. Those things are very important. On the next slide, I do have the email address where people are able to write to ICE to change their appointment or set an appointment if they haven't had one. This is the information that they want to see when you write to them. They can be written in Spanish, and they have responded back with dates that people can attend. It's important to print out that confirmation, and also if you're able to assist in people in securing transportation to this facility in Milwaukee, also really important so that people can be successful in their case. The immigration court is located in downtown Chicago. I always mention to people who are pro se, who will be attending court on their own, how important it is to know that getting to Chicago, which is a brand new area for them, often if they've come here to Wisconsin first, it's difficult to get downtown with traffic in the morning for a 9 a.m. hearing. Very important to leave with time so that people can get to their hearings on time and not face a possible removal order in absentia because they were unable to get to court on time. There's many different courts across all of the United States. And so you can see here a map of all of the different places where court is. You are assigned to court depending on the jurisdiction that you live in. The jurisdiction of Wisconsin has court in Chicago, Illinois. And so important to note that although people might be living here in Wisconsin, if they first lived in a different jurisdiction, they might have court in that place, and updating the address does not automatically change their venue to a different court. There is a special way where you have to ask for a change of venue in writing before the immigration judge, so that if you have court in Miami, you can change it to Chicago in a place that's going to be closer. If people do not ask the judge for this change of venue, it's important that people do attend court in the place where it is noted on either their hearing notice or online, and I'll show you briefly what that looks like. I mentioned earlier that some places do accept WebEx appearances. It's important to call ahead just to make sure that people are able to appear via WebEx. The last thing we want is that people are sitting in like a Zoom type waiting room and never let into the court hearing and removed in absentia. And so always the best bet, if people are able to travel to their court, for example, in Miami or Houston, that they do attend that court and that hearing and ask for a change of venue before the judge when they are there. WebEx, if should be a last resort, only because it is safer to ask for an appearance via WebEx, since not every judge and not every court uses it consistently. You're probably wondering and wanted to share, I like to prepare my clients for what the inside of a courtroom looks like, because it can be rather intimidating when you're going there on your own, and want people to be able to know what to expect. And so you can see there's counsel table for the government, counsel table or table for the respondent. The immigration judge sits at the head of the room, and then there's an interpreter and a court clerk that are also there. If this is one of their first hearings, or what's called a master calendar hearing, these are public hearings, and often these benches will be full of people waiting to be called by the judge. There's a few different ways to check when you have court. You can call this 1-800 number, which is a 24/7 hotline. It's not manned by a person, it's manned by a computer that's able to tell you whether or not you have court and when you have court, with judge often, and in which court. Or you can go online to this website. You do need the A number or the alien number for the individual to be able to find out when their specific court is. And so important to try and access this information if people might not have a hearing notice, or they've lost all their paperwork, but they do have their alien number. They can use this to try and figure out where to go next. You can often find the A number on this document called a notice to appear. You can also often see on the notice to appear where their next court date might be. You will want to double check that it is in the system and call the particular immigration court if there's any discrepancies there. On the next page, I show specifically where you can see the A number. This is just a fake notice to appear, but you can see their file number with a 9-digit code, or that's basically the number that is attached to the individual throughout their proceedings with the government, and it's used to identify them in court. And so very important to hold on to this paperwork and to that number as well. When you navigate to the online portion, this is what you see online. You can see the 9 boxes are for the 9 digits in the alien number. When you enter that number, it is possible that there's people who might not have a hearing yet. And so on the next slide, you'll see it says no case found for this A number. That means that their case might not be filed with the immigration court yet. That might be different from what you see on other paperwork. It's always safest to advise people to go to court if they have in hand a court date and a time that they are able to attend, because sometimes these things do not correlate. If there is confusion, they should talk to an attorney or call the immigration court to find out more about that discrepancy. If their case has been filed with the immigration court, you'll see something like this appear. You can see on the bottom right, there is a court address. This is the old court address in Chicago, so don't pay attention to that. But if they're venued in Miami or in Houston or in Los Angeles, you'll see the court address where they will need to attend court. And if they do have a hearing in the system, it'll show up like it does on the next slide, where you'll actually see next hearing information. You see who the judge is, you'll see the date and time, you'll see the court address that they need to be present at there. If it says that they have an individual hearing, that means that they are having their final hearing, basically the hearing where a decision will be made in their case. And so on the previous slide, I showed you a master calendar hearing. Here it says individual hearing. There is a difference between the two. A master calendar is sort of like a status conference, and the individual hearing is actually where a decision is made on the case. Very important to be aware that there could be a discrepancy between what's on the notice to appear document and what's in the system. It's important to rely on that system, but also to call the court if there are any discrepancies. Again, my advice is always that people go to court if they have something that says a certain day and time and they're able to attend. We don't want to risk in absentia orders. Often we get calls on, emergency cases that might not be emergency cases. And because there's low capacity here in Wisconsin for representation and for asylum seekers to seek legal representation, just have some criteria of things that are urgent. People who are detained, definitely an urgent case. Cases where a one-year filing deadline is about to pass, also very important. And cases where court is coming up soon, maybe it's out of town and they need to change a venue. Those are cases that are urgent where you should reach out to the Community Immigration Law Center or to a local attorney or a local legal service provider if these things are coming up. If there's no courts currently scheduled, or they don't have a court date in the near future, or their one-year deadline is far in the future, not as urgent. I know all of these cases are urgent. We want people to get work permits as soon as possible, but we do triage things here at our legal service organization because of the nature of the numbers that we're seeing and the inability to serve everybody. But just important to note that these are some of the criteria here. I did mention a change of address earlier, the EOIR 33, if people have to change their address with the immigration court, there's lots of ways to do it. They have to do it within 5 days, but they can do it online. And so one way to do that is how I've shared it here through their cell phone. They can do it online through the respondantaccess.eoir.justice.gov, or they can do it on the paper form online if they're able to print it out and send it into the immigration court and serve it also on the Department of Homeland Security or the ICE attorney. Working to wrap up here, important also for people who have to be in immigration court, EOIR does have a respondent access initiative where there are lots of YouTube videos and information in different languages on what immigration court is like. We've found some of those helpful for people who might be too far away in Wisconsin to be able to access our services here in Madison. So important to know that that is a great resource. And also want to just note unauthorized practice of law. It's important to know that we can help people find these resources as non-lawyers. We can help people figure out where to access things, make phone calls for them, translate for them. But you don't want to engage in the unauthorized practice of law. There are penalties for receiving compensation, for giving legal advice when you are a non-lawyer. And so very important to note that you don't want to be engaged in that. You do want to give resources and help people, but don't engage in the unauthorized practice of law because it is a crime in Wisconsin. So with that, I know that was a lot of information. I do want to be able to give people time for questions. It looks like, yep, in my information, at the Community Immigration Law Center is on the slide. There was a question, what are the circumstances under which undocumented individuals may be eligible to gain a driver's license in Wisconsin? Unfortunately, people who are undocumented in Wisconsin are not eligible for a driver's license. It's a fight that Voces de la Frontera, which is an organization here in Wisconsin, has been fighting for the governor to sign into law. But there are certain people who are undocumented and in removal proceedings who might have the appropriate documentation from the government that, might be able to share that with them. So that's important. Also have some questions here. Why is there such reluctance on the part of U.S. lawmakers to create a sensible guest worker program? I wish I could tell you that I knew. I know how important, immigrant labor is here in the United States to being able to uphold all of the systems that exist here. And so I'm hoping that there is a sensible way that we can start to give people safe ways to come to the United States, to work in the United States, to reunify with their families here in the United States. People deserve dignity in the process. Unfortunately, it's not a part of what exists right now, hoping that that changes in the future. There is no need for the legislature to accept asylum seekers officially. People are being bused to different jurisdictions, out of Texas to New York City to Chicago. At some point in the spring, Chicago was receiving 1,000 new people a week, or 1,000 new cases. The Chicago Immigration Court was receiving 1,000 new cases a week. They might be keeping up with that still. And so important to know that the state doesn't have to officially accept them, although we are seeing many states that are welcoming people with dignity and with resources as well. States like New York City, states like New York, states like Illinois, who are trying to use the legislature and state law to ensure that people are welcomed with dignity, ensure that people are welcomed and given hope in the process, maybe given resources for housing, resources to get a driver's license, and access to that information. We're very lucky here in Dane County to have the Immigrant Affairs Office. I know not every county has sort of an office for new Americans that we do here in Dane County, and we have social workers that help people navigate all of these difficult things, even if they're not asylum seekers, if people who are here as refugees, people who are here on lawful visas but are trying to figure out how to stay in the United States. And so there is growing resources here in the state. We're hoping that they continue to grow so that we can continue to welcome individuals and give them a warm welcome when they arrive to our communities, because our communities benefit greatly from the individuals that we are seeing here, from their families. And so we want to be able to welcome people with dignity in the process.
Thank you all so much for joining us today. And of course, thank you for Aissa for sharing your wonderful expertise.